Good morning. I'm Cassie Boggs. I'm a mining lawyer in Denver, Colorado. I've done a lot of international work over the last 35 years. And in particular, the last couple of years, I did some work in Afghanistan concerning the reform of their mining law. I was working as an intermittent mining law expert with the Commercial Law Development Program. And we're lucky this morning to have one of CLDP's lawyers who led the Afghan effort to talk about the reform of the Afghanistan mining law. So I'd like to introduce Anya Mallett. Anya?
Thanks, Cassie. It is great to be here today. I'm Anya Mallett. I'm a senior legal advisor for Commercial Law Development Program, or CLDP. I'm a mining attorney, but in the last 4 years, I have been focusing on Afghanistan, where I handle the mining portfolio. Prior to joining CLDP, I was an attorney in private practice in Denver, Colorado. Just a few facts about CLDP. We are the technical assistance arm of the United States Department of Commerce. CLDP is tasked with providing technical assistance in commercial law to governments and private sector of developing and transitional countries. Specifically in Afghanistan, we worked there since 2010 and worked with the Ministry of Mines and Petroleum to improve their legal regime, as well as increase capacity of the ministry's officials so they can effectively manage the mining sector. Cassie, I wanted to give just a few facts about Afghanistan. It's a landlocked country in South Asia with a population of 40 million people. It's about the size of Texas. In the last decades, its economy has been plagued with insecurity, political instability, lack of adequate infrastructure, and widespread corruption. Afghanistan's economy has been sustained by international donor aid since 2002. Over 50 countries have contributed, and the major donors include United States, United Nations, European Union, Germany, United Kingdom, and World Bank. Geologically, Afghanistan is part of the Tethyan Belt, the world's richest source of metals. Mining has been happening in Afghanistan since the times of Alexander the Great, but its mining sector is predominantly artisanal and small scale. Its growth has been inhibited by low processing capacity, lack of energy sources, poor transportation network, and insecurity. Informal mining, meaning mining outside of legal regime, is widespread, and it's estimated that over half of Afghanistan's mineral production has been either informal or illegal. In the last few years, a number of attempts have been made to develop Afghanistan's mineral potential. However, not much progress has been done to date.
Anya, that's very helpful in setting the stage. And of course, as we all know, Afghanistan has been in the papers a lot, certainly for a lot of reasons, controversial reasons. And we're not really here to talk today about the politics of that, but rather talk about this country that it has reportedly, it was reported in the New York Times to have between $1 and $3 trillion worth of valuable minerals, including things like copper and lithium and precious metals, as well as gemstones. So can you tell us a little bit about their mineral review, how people decided there were all these minerals in this country, and where that came from?
Afghanistan's mineral potential has been a focus of interest of sort of outside world since mid-19th century. And geologists from Great Britain, Russia, Sweden, Germany, a lot of countries looked into Afghanistan. And on the US side, US Geological Survey has been working in Afghanistan since 1970s. And then it returned back in 2003 when the United States presence in Afghanistan increased. So in 2004, US Geological Survey started looking into geological and mapping data that was collected by British, Russian, and Czech geologists. And in 2007, it released a preliminary assessment of mineral resources in Afghanistan. It was a comprehensive work, and it identified a wide range of resources, including precious metals, base metals, as well as construction materials, and lithium and rare earths. The same year, a large international tender was held for Mesainak, a copper deposit, making it the first international investment in Afghanistan. And then in 2009, USGS, working with the US Department of Defense, created a comprehensive database of 33 high potential areas or areas of interest. Those were the areas that could be very profitable if they were to be developed. Those were grouped into gemstones, base metals, and construction materials. I mentioned Mesainak. It is located 40 kilometers south of Kabul, and it is believed to be the second largest copper deposit in the world. In 2007, there was a large international tender, and several foreign mining companies, including Freeport, submitted their bids. It was eventually awarded to a company called MCC, which was a consortium of Chinese state-owned enterprises. So Mesainak became the first international investment in Afghanistan, and it was expected to bring $1 billion annually. Under the terms of the agreement, the Chinese investors were expected to build a railroad, a smelter, a power plant, a water distribution network, and a lot of other important infrastructure. MCC reportedly spent $300 million on developing the deposit. However, none of the infrastructure were built. And as of to date, this project is on hold. Now, the reasons often cited for that are the discovery of the ancient Buddhist ruins and insecurity at the site. But most likely, it is the different opinions of the Chinese investor and the government about what the obligations are under the contract that are holding this project back. In any event, nothing has happened over with it, and it has been talks about retendering this project just in the last few months. However, it didn't happen before the fall of the Ghani administration.
You know, that's helpful, Anya, because I think it shows how there's potential in Afghanistan for large scale mining, although obviously since 2007, this Mesainak this project didn't take off. You know, you couple that with, like I said, the 2010 New York Times article that discussed this $1 to $3 trillion amount of mineral wealth in the country. Can you talk a little bit about what that expectation, what that created in the country and among investors?
The 1 trillion estimate created a lot of expectation about Afghanistan's mineral potential, both within and outside Afghanistan. The government was very excited because it desperately needed the revenue. And the media reported that if every Afghan citizen would get a portion of the mineral wealth, everyone would get about $35,000. So as you can imagine, that was great news for everyone. And after 2010, the interest in Afghanistan increased dramatically, even though we were in the middle of financial crisis and the downturn in the mineral cycle. So by then there were two mega projects in the country: the Mesainak copper project, licensed to Chinese, and the Hajigak project, licensed to Indians. In 2012, the government announced a public tender for 4 additional projects that were part of those 33 AOIs identified by USGS. Eventually, the licenses were awarded to foreign investors. However, As of to date, only one of those licenses is still operational.
You know, we have this potentially very large copper project, Mezoniak, but what we know is that after that tender, certainly there were reports that came out, pretty credible reports, that the award of that tender had involved some pretty significant corruption and payments to people within the Ministry of Mines. So you have this potential, but obviously the legal system didn't seem to protect against corruption. Can you talk about the legal regime with respect to mining back then in 2007 and how it has evolved to try to address some of these issues?
In the last 10 years, Afghanistan had 3 mining laws. The 2000 law was perceived as unfriendly to foreign investors. One of the issues being the lack of security of tenure that linked the right to explore the mineral resource with the right to develop it. So in 2014, this law was replaced with another law that was intended to spur the mineral development. Reportedly, it was a comprehensive draft that was drafted with the input of private sector as well as international donors. It was passed right before the newly elected President Ghani took office. And as it turns out, the draft that was enacted had a few last-minute changes. The law was sharply criticized after it was enacted, mainly for lack of transparency and failure to combat corruption. Specifically, the rights of the names of the beneficial owners of a mining license were not disclosed, and the agreement between this investor and the government was not required to be published. The ministry actually defended this choice, explaining that there were instances of kidnapping when the beneficial owners were disclosed, and insisted on balancing the need for transparency with the safety of the investors. The law actually had other shortcomings that were described in 2015 review by Professor Otto. The law didn't provide for exclusive right by exploration license holder to obtain the exploitation license, meaning that the right of security of tenure was not addressed. The exploration license was available only through a competitive tender process, which works very well in oil and gas industry, but did not quite work in the mining sector. And the better choice would have been to allow the exploration license to be awarded by application. A mining contract, which is an agreement between the government and the investor that spells out the rights and obligations of both parties, was required for everyone, for every mine, however small it was. A very high level of discretion was awarded to the government. And the regulations from the prior law never been updated and remained on the books.
So that's interesting. What then caused the government to amend the 2014 law once again?
So as I mentioned, the 2014 mining law was enacted during Karzai administration, and Ghani administration felt that this law indeed did not adequately address the corruption and it was not transparent enough. So in late 2017, the government released a mining roadmap. It spelled out the new vision for the mining sector, recognizing that the mining is a driver for economic development for this country. The mining roadmap specifically mentioned the need to revise the 2014 mining law. So in 2018, the Ministry of Mines and Petroleum drafted a set of amendments and circulated those to the international donor community for review and comment. But a month later, a completely new draft was circulated by the Office of the President. This draft was created with the help of DLA Piper, who was government's legal counsel on the variety of matters that the government didn't have the expertise on. So this law was drafted by a very competent mining attorney, and was designed again to address the corruption, increase transparency, and to increase foreign direct investment. The law contained the process for tendering of known deposits as well as prospective geological areas. It contained approval process for granting licenses for exploration as well as exploitation. It required a mining contract. And as part of that contract, it required the company to submit extensive plans for environmental protection, worker health and safety, security plans for the mine site, and mandated extensive community consultation. The law also contained a number of provisions addressing illegal mining and promising a amnesty for illegal operations. It also incorporated a number of EITI concepts to address Afghanistan's transparency commitments.
So Anya, could you elaborate on EITI, what that is and what those concepts are?
EITI stands for Extractive Industries Transparency Initiative. EITI is a global standard for open and accountable management of mineral sector. Its primary purpose is to reduce corruption. EITI requires companies to disclose what they pay to the government, and it also tracks how those payments make their way through the government system and how they benefit the public. Afghanistan initially joined the EITI in 2010, but 9 years later, it was suspended for failure to incorporate the transparency requirements into its legal framework. And only last year, the EITI board lifted the suspension, and Afghanistan successfully completed its 2021 validation. One of the key achievements of EITI compliance was the transparency portal. It's a comprehensive database that was created with the help of international donors that contains the information on all of the licenses existing and as well as pending, information on all the contracts, as well as beneficial owners and all the payments that mining companies are making to the government.
Well, you know, it's interesting. So it looks like Afghanistan historically was a small and artisanal mining country. It has a couple of large projects that tries to get off the ground. It decides it needs to reform its mining sector, in particular to conform with best practices, particularly around alleviating corruption. And it becomes a member of EITI, which arguably altogether would bring Afghanistan into having a modern legal regime, a modern mining legal regime that would be attractive to foreign investors. So was there a flood of foreign investment applying for licenses?
Well, not really, Cassie. In addition to sort of concerns that investors would have had about security and lack of infrastructure, there were a few things that could have contributed to that lack of interest. One is, compared to prior law, this new law was a step forward and addressed the security of tenure issue and provided for priority of the exploration license holder to obtain the exploitation license. But even though the government was assisted by a competent mining attorney, and even though the government did receive the advice from international donor community, it chose not to incorporate a lot of best practices. The law did not allow for exploration license to be obtained by application. It required a mining contract for every mine. Again, every small mine was required to go through that process. The government decision-making did not have clear standards spelled out in the law. The biggest issue, however, was a very lengthy approval process for award of a mining license. To get a license, a mining company had to go through 18 steps with approvals from various government agencies and organizations such as Mining Technical Committee, National Procurement Authority, the Cabinet, the National Procurement Commission, High Economic Council. So the government chose that approach to combat corruption that was allegedly widespread at the ministry at the time. But what it ended up with is a process that was not workable at all. And it would have taken a company 4 years to go through the process like that. So another issue was that the law never been fully implemented. The law required a mining contract to be negotiated for each exploration and exploitation license, but the model contract never been completed. Another issue was that the Mining Technical Commission, a body that was required to make technical decisions about the mining licenses, it never been convened because the law required a legal, technical, and financial experts to have 10 years of experience and required that most of those people should be Afghan citizens. So the Mining Technical Commission was never staffed. And since law came into force, the government attempted to tender a number of properties. However, none of the licenses were awarded under this new mining law.
So, it sounds like there were lots of efforts to reform their mining law and bring it up to sort of best practices and international standards. But there in the end really wasn't much foreign direct investment, in part because the law never got fully implemented.
Yes, lots of effort was made by international donor community to make this law successful. There were advice and reports that were prepared for the government in hopes that they will incorporate international best practices. But as time shows, those suggestions were never taken into consideration and nothing was really implemented.
Well, and it's interesting in what we found, I think, after the 2018 law was passed, was, as you said, it wasn't fully implemented, but the government immediately started talking about amending the law again, and as well as started making public statements at PDAC and in other mining venues that seemed inconsistent with the existing framework. Can you talk a little bit about these inconsistencies and the impact that then had?
Yeah, in early 2020, just a year after the new law was enacted, the government started making announcements at various meetings. And even though its purpose was to boost the confidence of international investors, I think it just worked the other way. The government announced the creation of the National Development Corporation, which was a state-owned company with 10 branches, one for each of the priority minerals that the government designated. The problem was that this entity was not envisioned under the new legal framework, and there was no mechanism to grant mineral rights to it. The government also talked about sole source contracts and then government-to-government investments. Again, that mechanism was not envisioned in the new mining law. And in fact, it was in direct contradiction to it. The government also decided that the Afghan Geological Survey is going to conduct exploration and designated a number of projects that they're going to be working on. And again, the issue with that was that Afghan Geological Survey was not given a power to conduct exploration under the new mining regime. And even though the geologists that were in the AGS are very well-trained people, there was just not enough capacity for the survey to take on such a project.
I think it's interesting. This is a good example that shows that you can have a very modern legal regime, but one, if the government doesn't implement it and act consistent with the law, then that doesn't serve its underlying purpose of encouraging investment. But secondly, and you've spoken about this a couple of times, about the lack of capacity within the government to actually undertake what the law requires, and then in some cases, what the law doesn't require, but what the government is saying it's going to do, including this idea that the government of Afghanistan apparently thought that there was no, they weren't getting a lot of foreign investment because they didn't have enough geologic information, exploration information about their deposits. And so they decided they would undertake that. But as you know, that is a very, exploration can be a very expensive task to undertake with, small likelihood of success. I think the plan was the government assumed that the international donor community would finance this. But maybe you can talk a little bit more about this lack of capacity and how that impacted sort of their ability to implement a sort of state-of-the-art international law.
Yeah, the ministry had very talented lawyers, but they did not have much experience with international best practices in mining and regulatory regime, or for that matter, in the mining sector in general. So as a part of the US government effort to raise capacity of the ministry officials so they can adequately administer the new mining law, CLDP partnered with US Geological Survey and created a mining course that was specifically designed for the ministry officials and the officials from Afghan Geological Survey. So it was a multi-year course with the main objective of creating a core group of officials who will be able to acquire knowledge and skills and manage the mining sector efficiently. So the legal participants would understand what the new law says and what are the best practices to implement it. And then the technical participants would be able to conduct surveys and analyze and interpret the geological and economic data. We use the trainer approach, meaning that the core officials would go to their respective departments and train their employees in what they learned within the course.
Well, I think this is a good example of, because this is a problem that I think many developing countries have, which is they can reform their mining law, but you have to have lawyers and regulators and technical people who can then implement the law and properly enforce the law. And I think it's a very common problem that, particularly among the lawyers that oftentimes work for ministries of mines, that they develop some expertise and they get snatched away either by private industry or they move on to more lucrative jobs. So it takes, at the end of the day, it takes a very long time for a country to build up capacity within its Ministry of Mines. The other thing it seems in what you're saying is that the government developed a kind of modern mining code, but other things didn't get done that would have, it was sort of completed 80%, but the other 20% didn't get done. And that had some added impact too. Can you speak to that a little bit about the process and how they went about trying to implement the law, even though they didn't have things like model contracts?
Although the tenders for the 4 major projects were conducted in 2012 and the bidders were selected, it took the government 6 years to issue the licenses, and then it only issued 3 of them. So the winning bidders had a very hard time raising funds for exploration. And there were also allegations of corruptions. And the 2 contracts were issued to a company that had a shareholder holding a high government position when the tender was held. So there were also issues with a timely return of bid bonds by the government. In one instance, it took a government the entire year to do that. And then in the very end, the government canceled those 2 contracts, citing the company's inability to meet its contractual obligations.
So what we see is under the 2014 law, even though some contracts were issued or some the bids were won, it ultimately didn't result in contracts being issued. It took bidders a long time to get their bid deposits back. the government, so the government's, and the government never has issued any licenses under the 2018 law. So kind of a bad history there, a lack of capacity. But interestingly, in September last year of 2020, the government entered into an agreement with an Australian company. Can you talk about that a little bit?
So last year, the government and the Australian company Fortescue signed an agreement titled Framework Deed of Agreement. It gave the Fortescue the right to explore for any mineral anywhere in Afghanistan for the term of 5 years. It was negotiated on the very high level of the government. And once the agreement became public, the issue kind of became whether this agreement is binding and what are the rights of the existing exploration rights holders, license holders. And it appears that agreement is binding, given the fact that it contains the arbitration provision. But the problem with this agreement conceptually is that it did not require a company to go through a public tender process before obtaining a right to explore the resources in Afghanistan. Also, just 4 months before the Ghani government fell, the media reported that during a trade mission to Czech Republic, the Afghan officials promised 2 mining contracts to be awarded to a Czech company, again, bypassing the public tender process.
So Anya, this is, all of this is very helpful. And I think sort of forms a set of examples around what happens in many countries that are trying to reform their mining law. In particular, because with this energy transition, lots of countries have figured out that they need their mineral resources are a source of wealth for the country that need to be developed. So oftentimes, as Afghanistan has done, countries will look to the international donor community to assist them in revising their legal regime. And obviously Afghanistan had a lot of assistance in doing that. Can you talk about that process and maybe what worked or didn't work and how it could have been done better?
Yeah, looking back, oftentimes there are multiple donor agencies that are offering assistance. And in Afghanistan, it was over 50 of those donors. It was United States, it was its allies, it was international organizations, bilateral donors. So the problem was that the advice that was given to the government was not always consistent. And the key is probably to develop a system where all pieces of advice are coordinated and complement each other. If all international donors work together to come up with an agreed legal regime, the government would get a coherent message and will be able to implement it. Another really good thing is to empower the government to take ownership and to coordinate the advice that it's receiving from its end. And that will also ensure that the government will be able to understand the message and to implement the recommendations it's receiving.
Thanks. One of the other clear examples that came out of your discussion of Afghanistan is just, again, the lack of capacity, both legal capacity within the Ministry of Mines and regulatory capacity. Can you talk a little bit about how an undeveloped country can try to develop that expertise?
Because developing countries don't have human capital, infrastructure, and the educational institutions that are needed to develop the expertise, international donors are in the best position to offer their assistance. There's been a lot of research done on what are the best practices in capacity building, but ultimately the answer is there's no one-size-fits-all approach. In designing our mining course for the Ministry of Mines and Petroleum, we conducted the assessment of the government needs and then decided that the long-term training was the best option. We also secured agreement from the ministry that the training will continue even though the mining course will be completed. And so we utilize the train the trainer approach. We also made the application process competitive and selected the participants based on their expertise and experience, and also the commitment to train others. We encourage the ministry to take proactive role in selection of the participants and to provide incentives as well as disincentives. As one of the incentives was to increase salaries or offer promotions to people who complete the course, and to execute contracts, employment contracts with the officials, so they are obligated to stay within the ministry and train the employees after they complete the course. And again, it worked very well for us with the technical people, but it didn't quite work with lawyers. It could have been that the salaries for lawyers in the private sector are much higher than with the government. And so, you know, the experience in the very end went from, you know, the government into the private sector. So at least it remained within the country.
So it's, as I said, and you said, you know, the lack of capacity is a problem, not just in Afghanistan, in a lot of developing countries, and developing capacity takes many years. It has to be seen as a long-term project. The other point you mentioned, Anya, is that the government at one point decided to develop state-owned companies, essentially one big company with different divisions for each of the 10 strategic minerals that it identified. You know, it's not uncommon in countries, resource-rich countries, that they have state-owned companies, particularly in the oil and gas sector. And, you know, Chile is a good example. Codelco is its state-owned copper producer. So you see state-owned company or state-owned enterprises in other countries, but tell me, is that a good idea, a bad idea, particularly for a country like Afghanistan? Is that going to facilitate development of their mineral resources?
You know, Cassie, from multiple reports and lesson learned that we, you know, seen about the state-owned enterprises, we know that those vehicles often tend to be less efficient and require extensive government subsidies, and generally lack good governance as compared to the mining sector. And for a successful SOEs, you need a well-defined ownership policy, and you need strong corporate governance with the board of directors that can make independent decisions. And only when the SOEs are accountable to their shareholders, that's when it's going to work. And again, another important piece is that the management team needs to have people who have proper skills and they're educated in the subject matters that they are managing. And Afghanistan does not have a lot of skilled professionals, and it will be a challenge to create a state-owned company that will be able to function successfully. Historically, Afghanistan had 4 mineral state-owned enterprises, and only one of them was able to function over the years consistently, probably because of those issues that I just talked about.
And as I recall, those government entities all required government subsidies. So from an economic point of view, state-owned enterprises end up taking money from the government, not necessarily producing additional revenue, but also require quite a significant amount of skilled professionals, both technical and legal. And as we know, Afghanistan does not have a big supply of that. You know, lots of countries, including Afghanistan, point to Codelco and say that's what they would like to develop, but it's a challenge to do that, and really requires some long-term thinking of how you're going to achieve that objective. I think, you know, what all of this has suggested is that even if a developing country, has the best legal regime, the most up-to-date international legal regime, if you don't have the right people and a government that is interested and dedicated to ensuring that that law is implemented, that it still doesn't achieve the objective of getting more foreign investment and combating corruption and creating a long system that will work in the long term. And of course, you know, I think there are examples elsewhere in the world where, for example, Greenland has recently elected a government that was, part of its platform was that it was going to reject the development of a large rare earth mine. But when you look at Greenland's another country that realized its mineral potential and about 10 years ago revised its mining law, again, to create a very modern mining code, which it's done. And there are, I think there are examples of mining operations in Greenland. But this particular operation met with a lot of community distrust, and they ultimately, those local the local community and the people that were potentially going to be impacted by the mine ended up voting in politicians who would not let the development go forward. And what that says to me is sometimes it's important to have the right legal regime, but mining companies can't ever forget that not having the social license is equally as important to being able to develop your mineral resources. And with that, I thank you, Anya, and we would look forward to any questions people have about Afghanistan's mineral regime specifically, but more importantly, how that experience, I think, can be considered in other parts of the world. Thank you.